Important update, and those pictures from that school protest are quite moving and overwhelming. Let's get some important legal insights now. The former federal prosecutor Elliot Williams is with us, and the retired LAPD police sergeant Cheryl Dorsey. She's also the author of Black and Blue, Creation of a Social Advocate. Let me start with you, Sergeant Dorsey. You just heard Lucy laying this out. I'm going to read you. This is from the probable cause statement released by the detectives yesterday. Lester stated it was the last thing he wanted to do, but he was scared to death due to the male's size and Lester's age and inability to defend himself. That is the statement given by the shooter, Mr. Lester. Listen to the aunt of this teenager saying, doesn't make any sense. Listen.
I doubt Ralph is even 170 pounds. Ralph is not even 6 feet. Like, Ralph, when you see Ralph, in all of the pictures that you have seen on social media and everywhere else, I don't see how you see fear. I don't know how you can see fear when you look at that kid.
The charges, Sergeant Dorsey, tell us what the prosecutors think, but there is a stand your ground law, and you would assume the defense would say that Mr. Lester felt threatened. How do you see this as someone who's investigated such things?
Well, listen, by the police chief's own admission, there is a racial component. We know that to be true. There was a young Black child in a predominantly white neighborhood, according to reports, who had probably in Mr. Lester's mind no business being in that community. And he had the temerity to come to his door and ring his doorbell. And so we know that this suspect looked out and saw this Black child, became fearful of his Black skin, and decided the only thing that made sense for him to do was shoot him. He was so fearful of this Black child that he opened the door to shoot him a second time. All unreasonable, all nonsensical, and it stinks to high heaven. And why is this man not in custody? He's a menace to society. There could be another Black child right now walking in that neighborhood who he might see, fear, and shoot. If he looked like me, he'd be in custody, I promise you.
Elliot Williams, Sergeant Dorsey makes a point in the sense that why? He was questioned, then released. There was a discrepancy at first about how long he was kept then. But you have the charges filed. Why at least not a court appearance? Whether you arrange for bail and whether you think he's not a flight risk, that's one question. But why does the community not get the satisfaction to see that the process is playing out?
It's perplexing, John, and it's probably a quirk in Missouri law that allows defendants to be out. Now, I know that there's a 24-hour period while they're conducting an investigation after an initial meeting with an individual where they allow the person to be released. It is a little bit perplexing that they haven't brought him in. I would assume they would schedule something very quickly and get him to answer to the charges.
And Sergeant Dorsey, back to you on a potential factual dispute here. In the probable cause statement, it says Lester, the man who owns the home and fired the gun, stated no words were exchanged during the incident and the male had not said anything prior to pulling the door handle, versus the teenager advised he did not pull on the door. And this was the first time coming to the residence. I understand your perspective on this. You made that quite clear. But from a police perspective, fingerprint test of the door handle, is that enough to resolve this factual dispute? What would you do?
Well, that's certainly something that can be done, and it may very well occur. But of course, now that this suspect has fired shots and injured gravely a young man, he's got to come up with a story to justify this unreasonable use of deadly force. And so if he was as fearful as he says he was, he certainly had options. I understand this is a stand your ground state. He's inside. His door is closed. He's secure.
So walk us through the law, Elliot. In the state of Missouri, states have these laws, and they're different depending on the state. Sergeant Dorsey makes a critical point. First shot was fired through a glass door.
Yes.
The door was locked. Mr. Lester then opens the door and fires a second shot. That does not sound like standing your ground, but what does the law say?
Look, stand your ground laws are often very comprehensive and provide protections for people who have firearms and use them. Here, he would need to establish that he reasonably believed that the use or imminent use of violent force was coming his way. Now, a couple of the facts, even of the ones that aren't in dispute, that number one, he's standing outside. Ralph Yarl is outside the door. Number two, the shot comes through the door. Number three, it's not till the door is open and Yarl is on the ground that Lester fires the second shot. It's a stretch to say that he was in fear of the imminent use of force at that moment. Like, even setting aside the fact that Missouri does have this protection for gun users or gun owners, it simply isn't the case here.
The facts seem well beyond the lines. Elliot Williams, Sergeant Dorsey, appreciate your insights today. We'll, of course, stay on top of this investigation. And again,